The things we're going to look at today, we're going to start off by looking at what happens when the sole shareholder passes away. So we're going to look at the transmission of shares and the practical problem tied in with that. We're also going to look at how the articles can assist. Now, brilliantly, the model articles do help in this situation. So we're going to look at the model articles provisions for how the executor can appoint a director. We'll also talk about Table A. We'll then think about why we can't rely on the duomatic principle in these circumstances. We'll talk about how you can apply to courts to rectify the register of members. And we'll look at some recent cases that have actually supported the issue. And then we'll finish off by thinking about practical ways we can actually plan ahead to avoid the issue arising at all. So, if you have the model articles for a private company limited by shares and you haven't amended model article 17, you have a get out here in this scenario. So model article 17 paragraph 2 says, in any case where, as a result of death, the company has no shareholders and no directors, the personal representatives of the last shareholder to have died have the right, by notice in writing, to appoint a person to be a director. And then you've got your person who's been appointed as a director. That director can then register the transfer of the shares as we discussed earlier. So that's the point where the director can write up the new shareholder, whether it's the PRs or the beneficiaries, in the register of members. So you can see that the articles get us out of this awful problem. Model Article 17, paragraph 3 also says, for the purpose of paragraph 2, where 2 or more shareholders die in circumstances rendering it uncertain who was the last to die, the younger shareholder is deemed to have survived an older shareholder. So the articles helpfully get us away from the problem.